General discussion on the law on partnership. The law on partnership is covered by Articles 1767 to Article 1867 of the new Civil Code of the Philippines. So we start with the definition of a contract of partnership and what are the requisites. Okay? In your Article 1767, you can find the definition of partnership. Okay, by the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. Two or more persons may also form a partnership for the exercise of profession. Okay, that is the definition. We go with the requisites. The essential requisites of a contract of partnership are, there are four. 1. There must be a valid contract. 2. There must be a contribution of money, property, or industry to a common fund. Number 3, the partnership must be organized for gain or profit. And number 4, the partnership should have a lawful object or purpose and must be established for the common benefit or interest of the partners. Okay, remember the four essential requisites of a contract of partnership. So, what is the test or the indicia to determine whether or not there is a partnership? There are always two tests which must be applied in order to determine whether or not a partnership exists. The first test is to determine whether or not there is an agreement to contribute money, property, or industry to a common fund. And the second test is to determine whether or not there is an intent of the contracting parties to divide the profits among themselves. Okay? Once it can be shown that there was an agreement to contribute money, property, or industry to a common fund, and there was an intent to divide the profits among themselves, then there is a contract of partnership. Okay? That is found in the case of Evangelista versus the Collector of Internal Revenue, okay, and the case of Negado versus Macabenta. So, next, follow-up question. Assuming that there is a mutual contribution of money, property or industry to a common fund, is the receipt by a person of a share of the profits of a business conclusive evidence that he is a partner in the business? The answer there is no, because okay, it is not a conclusive evidence that he is a partner in the business, because according to the new civil code, okay, it is merely a prima facie evidence that he is a partner. This inference, however, cannot be drawn if such profits are payment for the following. 1. Debt payable by installments or otherwise. 2. Wages of an employee or rent to a landlord. 3. Annuity to a widow or to a legal representative of a deceased partner. 4. The interest on a loan. Number 5, sale of the goodwill of a business or property by installments or otherwise. This can be found in the Article 1769 of the new Civil Code. Next question. Okay. Can a partnership or a corporation enter into another partnership or corporation? Okay. This is the answer of the Supreme Court in the case of J.M. Tuason and Company versus Bolaños, 95 Phil 106, decided on May 28, 1954. Okay, the Supreme Court said that it is a rule accepted in our jurisprudence that a partnership cannot form another partnership. In fact, a corporation cannot be a partner in a partnership on the ground of public policy. Otherwise, people other than the officers can bind the corporation. However, it can enter into a joint venture with another corporation where the nature of the venture is in the same line of business authorized under its charter. Ano po ba yung joint venture? Okay? A joint venture, okay, being a form of partnership, it is to be governed by the laws of partnership. Next instances or next questions. Okay? What happens when a partnership is unlawful? Okay? So, the consequences in case the partnership is unlawful. If the firm is guilty, okay, if the firm is also guilty of a crime, the revised penal code governs both the criminal liability and the forfeiture of the proceeds of the crime and the instruments of tools with which it was committed. Such proceeds and instruments or tools shall be confiscated and forfeited in favor of the government, unless they be the property of a third person not liable for the offense. But those articles which are not subject of lawful commerce shall be destroyed. This is provided in your Article 45 of the Penal Code. Also, the partners forfeit the proceeds of profit, but not their contributions, provided no criminal prosecution has been instituted. If the contribution have already been made, they can be returned. If the contribution have not yet been made, the partners cannot be made to make the contribution. And lastly, the unlawful partnership has, of course, no legal personality. So, case. An organization, okay, an organization XXX company was engaged in conducting lottery among its partner members every weekend. The members contributed a weekly amount, all of which except a certain amount were distributed in turn to the lottery winners. Obviously, the court had no alternative except to declare the partnership an unlawful one. Question: can the partners get back their capital profits? The answer: the partners can get back their capital, for the law speaks only of the confiscation of the profits, which certainly should not be returned. First, because of the express provision of the law on profits, and second, because to legally get profits, the action must be based on a lawful contract or transaction, not an illegal one. Okay? Recovery of the capital indeed may be had, okay, except if the same can come under the category of instruments and effects of the crime. Next case. Okay? What are the important formalities or requirements if there is an immovable property that is contributed in a partnership? This is Article 1771. Okay? I will give you a case. A problem is this, okay? Sorry. A partnership was formed orally, though more than 500 pesos was contributed in cash. Now then, under the last paragraph of Article 1358, contracts where the amount involved exceeds 500 pesos must appear in writing, even in private one. Question: should the oral partnership form be considered valid? The answer there is yes, because Article 1358 applies only for the purpose of convenience and not for validity or enforceability. Being valid, the contract can be put in writing upon the demand of any of the parties. This is decided by the Supreme Court in the case of Magalona versus Pesaico, 59 Phil 453. Okay, note, however, had real property been contributed, the oral partnership would be void. Okay, and therefore not one of the parties can compel the others to execute the public instrument. Kindly see Article 1773. Next, if two persons agree to form a partnership in the future, okay, does that Does the partnership immediately arise from the moment of said agreement? The answer there is no. Okay? An agreement to form a partnership does not of itself create a partnership. When there are conditions to be fulfilled or when a certain period is to elapse, first, the partnership is not created till after the fulfillment of the conditions or the arrival of the term. And this is true even if one of the parties has already advanced his agreed share of the capital. Okay? Moreover, there is a marked distinction between a partnership actually consummated and agreement to enter into partnership at a future time. Okay? So long as an agreement remains executory, the partnership is only inchoate, okay, and not having been called into being by the certain action necessary under the partnership agreement. This is the case of Limuco versus Kalinao, GR number L-10099. Okay? Next, what is the effect of non-registration of partnership? First, even if not registered, remember this one. Okay? Even if the partnership is not registered and the partnership has a capital of 3,000 or more, as provided in Article 1772, okay, the partnership is still valid and therefore has legal personality. Of course, note, however, of course, if real property had been contributed regardless of value, a public instrument is needed for the attainment of legal personality. Okay? So, the second case, if registration is needed or desired, any of the partners of a valid partnership can compel the other to execute the needed public instrument and to subsequently cause the registration thereof. Okay? Note, however, that this right cannot be availed of if the partnership is void. Remember that in your Article 1773, the following are the requirements where immovable property is contributed. Okay? Kung may immovable properties such as land, building, ganyan, ang involved sa isang partnership, the following must be complied with. Number 1, there must be public instrument regarding the partnership. And number 2, inventory of the realty must be made, signed by the parties, and attached to the public instrument. Okay? The Article 1773, okay, applies regardless of the value of the real property. It also applies even if only real rights over the real properties were contributed. And lastly, Article 1773 also applies if, aside from the real property, cash or personal property is contributed. But here, the inventory need not include the personality. So, there are many kinds or classifications of partnership. Okay? According to manner of creation, okay, it can be made through oral, it can be constituted in a private instrument, or in a public instrument, and registered in the Office of the Securities and Exchange Commission. According to object, it can also be a universal or particular. When we say universal, it includes all present property and with all the profits. And when we say particular, here the object are determinate things, their use or fruits, and a specific undertaking or the exercise of a profession or occupation. According to liability naman, there are two, the limited partnership and the general partnership. Okay? When, in case of limited partnership, that where at least one partner is a general partner and the rest are limited partners. Note, however, that a general partner is liable beyond his contribution. So, kahit sa personal property niya maaapektuhan sa isang general partner. While in a limited partner, okay, he is only liable only up to the extent of his contribution. So, in a general partnership naman, okay, that where all the partners are general partners. According to legality, it can be lawful or legal, or illegal or unlawful. According to the duration naman, for a specific period or till the purpose is accomplished, and one that is a partnership at will. Okay? Ano ang partnership at will? One that has no period. It can be expressed or implied and is given so its duration depends on the will of the partners. Okay? Kung kailan gustong tapusin. Nasa kamay ng mga partners kung kailan nila gustong tapusin yung partnership, yung duration ng partnership. Okay? And lastly, if according to representation to others, it can be in ordinary partnership or partnership by estoppel. Ano yung partnership by estoppel? Okay. An example is in the case of McDonald's versus National City Bank of New York, 99 Phil 156. Okay? When two or more persons attempt to create a partnership but fail to comply with the legal formalities essential for juridical personality, the law considers them as partners, and the association is a partnership insofar as it is favorable to the third person by reason of the equitable principle by estoppel. Ano naman ang partnership de facto? Okay? Ano naman ang partnership de facto? This is decided by the Supreme Court in the case of Andres de Jesus et al. Versus Nicanor Padilla. Okay? GR number L dash 121191 R April 1955. Okay? If upon the death of the wife, the husband continues to manage the formerly conjugal properties now owned by him and the common children, and said children allow their father to manage the property without even causing their rights to the property to be recorded in the office of the registry of deeds, okay, or in the assessor's office, a partnership de facto has been created. It is therefore to be presumed that all the facts performed the father as managing partner were for the benefit of all the partners. That is an example of partnership de facto. Remember that in a universal partnership of all present property, ano yon? This can be found in Article 1778, okay? Based on your Article 1777, there are two kinds of universal partnership. It can be a partnership of all present property and partnership of all profit. Okay? Present property, tapos yung isa, profit. Ano naman yung universal partnership of all present property? The contribution here consists of 1. All the properties actually belonging to the partner, and number 2. Profits acquired with said property based on Article 1778. I will give you a hypothetical problem on all present property. Example: A and B entered into a universal partnership of all present property. No stipulation was made regarding the other properties. Subsequently, A received a parcel of land by inheritance from his father, and another parcel of land from the San Beda College as remuneration for A's work as professor therein. Question: are the two parcels of land and their fruits to be enjoyed by the partnership? The answer there is no, because there was no stipulation regarding the future properties or their fruits. Based on your second question, based on the previous question, okay? Except that, okay, same as on the previous problem, okay, except that in the contract, it was stipulated that all properties subsequently acquired would belong to the partnership. Ano naman ang mangyayari? The land acquired as salary as well as its fruit will belong to the firm. Okay? Bakit? Kasi nga stipulated na all properties subsequently acquired. Okay? Subsequently means follow yung mga future na ma-acquire, okay? It shall belong to the firm or to the partnership, of course, but the land acquired later by inheritance will not belong to the partnership. Bakit? since this cannot be stipulated upon, okay, based on your Article 1780. The fruits of the inherited land will go to the firm. Okay? Yung fruits ng inherited land will go to the firm because said fruits may be considered as properties subsequently acquired. And there is no prohibition to stipulate on fruits even if the fruits be those of properties acquired later on by inheritance, legacy, or donation. So in this case, okay, if there is a stipulation that all properties subsequently acquired would belong to the partnership, yung salary, okay, it shall form part of the partnership or the firm. Yung land na namana nung ni A doon sa kanyang tatay, it shall not form part of the partnership kasi nga hindi to na-stipulate. Okay? Pero yung mga fruits, for example, dun sa lupa na yon mayroong building at yung building na yon is pinaparentahan. The fruits or the rent income in that immovable property shall form part of the fruits of the partnership. Okay? Another case naman, another hypothetical problem on profits naman. Tapos na tayo dun sa all present property, ha. Ngayon, let's go to the on profits naman. Di ba may dalawa? Isa is yung all present property, which is yung kakatapos. Tapos, the next naman na example natin is partnership of all profit. Ano naman ito? Example. In a universal partnership of profit, Anna contributed the use of her car. At the end of the partnership, should the car be returned to him? Ibabalik ba yung should the car be returned to her? Ibabalik ba yung car na ginamit during the partnership kung tapos naman na yung partnership? The answer there is yes, because the naked ownership had always been with Anna. And upon the end of the usufruct is the right to enjoy things. Okay? Full ownership reverts to her. Reverts meaning to return to her. Remember that only its use or the usufruct had been previously contributed. Okay? Not the property itself. Another case. Anna and Ben entered into a universal partnership of profits. Subsequently, Anna won first prize in the sweepstakes. Okay? Will the money belong to the partnership or not? Okay, the answer there is of course no, because it was not acquired by industry or work, but it is only acquired through by chance. Okay? So, remember that in a partnership, ang tatlo lang i-kino-contribute dyan. Money, property, or industry. Yung price dun sa sweepstake, hindi yun pinagtrabauhan. Okay? Hindi yun pinagtrabauhan, hindi yun minana. Okay? But it is merely by chance. Okay? So, since it's not an industry or work, then it's not part of the partnership. So, the answer there is no. Another question. Anna and Ben entered into a universal partnership of profits. Subsequently, Anna became a teacher at Poveda Learning Center. Will Anna's salary belong to the partnership? Ginawa ko ng example kanina yan. The answer there is yes. Because even though there is no stipulation made on this point, because after all the salary was acquired by Anna's industry or work during the existence of the partnership, such profit belongs still to the firm as a matter of right. Okay? Of course, had there been a stipulation that such salary would be excluded, the stipulation would be valid. In this case, the salary belongs to the partnership as a matter of right. Okay? Next. Anna and Ben entered into a universal partnership of profits. Later, Anna purchased a parcel of land. Will the fruits of said land belong to the partnership? The answer there is the answer. The general rule is that no. Okay? So, the fruits of the land will not be given to the partnership because the right of usufruct or the right to use and the fruits granted to the firm under Article 1780, paragraph 2 refers only to that of the property possessed by the partner at the time of celebration of the contract. Remember at the time of celebration of the contract, kung kailan daw ginawa yung kontrata. It follows that fruits of after acquired property, okay, yung mga na-acquire after, okay, do not belong to the firm as a matter of right. Magkaiba to dun sa kanina kasi yung kanina is all present property. Okay? However, it would be valid to stipulate that the use of right of after acquired property would belong to the partnership. Remember that one. In your Article 1782, the states for the persons who are prohibited from giving each other any donations or advantage cannot enter into a universal partnership. Ano tong mga to? Example of persons who together cannot form a universal partnership. Example is number 1, the husband and the wife. Okay? This is provided in your Article 3133 of the New Civil Code. Another is those persons guilty of adultery or concubinage. Ano to? Ito yung pangangabit. Ito yung mga mag-asawa. Kung wala kang asawa, hindi mo to makukommit unless it is together with a person who is married. Okay? Kung yung kabit mo is married. Okay? Those guilty of the same criminal offense if the partnership was entered into consideration of the same. Okay? I will give you an example. Okay. Question number 1. Can a husband and wife enter into a contract of partnership? Of course. Kakasabi lang natin. Okay, this is the answer. If the partnership is a universal partnership, a husband and a wife cannot enter into a contract of partnership. This because under Article 1782, persons prohibited from making donations to each other are also prohibited from entering into a universal partnership. However, if the partnership is a particular partnership or a limited partnership, they can. So, ulitin ko, kung can a husband and wife enter into a contract of partnership, tignan nyo muna kung anong kind ng partnership. Kung universal partnership, it cannot be. Okay, but if it's a limited or a particular partnership, the husband and the wife can enter into a contract of partnership. Next question. We go now to the obligations of the partners. Okay? The obligations of the partners among themselves. I will discuss that on the second video or recording. Thank you for listening and sana may natutunan po kayo.